Good morning, good afternoon, good evening, everyone. We are having people who registered from many areas in the world. Thank you for joining this webinar that is organized by the European Joint Programme on Rare Diseases on intellectual property rights. So we organized this webinar by the end of EJP-RD, capitalizing on the results that were generated, and we tried to format it so that you can benefit from it for your current activities, but also the further activities there. So we have 230 registered participants. You are all coming to the webinar one by one. So I'll be sharing my screen right now because we are tight on time. And just as an introduction, so we have set a Mentimeter that is opened to all of you during the whole duration of the webinar. Should you have any questions, all the questions that are submitted, you will be able to vote on them in order to feature the ones that you would like us to address most. We do not expect that we will be able to answer to the all questions. Thus, this option that is provided to you. I provide also the link to the Mentimeter in the chat, and it will be pinned on top so that you can see it during the whole webinar. Just click on the link or scan the QR code or follow the instructions on menti.com and you enter the code displayed, and you will be able to get access to the Q&A webinar. No speaking further, so I hand over to Barbara for introducing what is this webinar and what it is not. Thank you.
Thank you, Yanis. So the idea is to share with the EJP-RD community and all the others that join us today for this webinar an overview of what are the key aspects of using intellectual property instruments to better support your research results and your research project, especially considering issue like drug development, therapeutic development in rare diseases. So this webinar is not a technical course on intellectual property. Its aim is to raise awareness on these topics, try to make it accessible to researchers which may not be so confident on this topic, and give you instruments to better talk with your technology transfer offices and your institution in order to find the best way to further develop your research results in your project. So please, Yanis, stop me if we have some issue. So just a brief overlook of the agenda. So we'll start with an introduction about the topic of managing intellectual property in your research. And then Matthew will dig a bit in IP strategy regarding software, which are one of the main results during the achieved during the EJP-RD action. And then we will have, at the end of this part, the first Q&A. So please submit your answers to the Menti system like Yanis suggested. We will have the most boring part in the middle, just before the coffee break, which will be about how you manage your IP rights and your joint results. My camera is flashing, however, and under the European grants. And then we will have a break and we will go with some case studies. So let's move on. So for those who never who never meet me, I'm Barbara Sanavio. I'm with the Business Development Office at Fondazione Telethon, where I take care of technology transfer and business development aspects of the research generated within Telethon Institute. And we are going to share some of the answers we give our researchers when they contact us. So a couple of definitions just to set the stage. And so what is intellectual property? At the end of the day, intellectual property is about your research results. Some of them may be classical protectable intellectual property by means of patent application or copyright, or know-how. Please note that in common language, we use know-how to define the expertise we gain in our work during our research, but from an intellectual property point of view, it has a very defined meaning. So you can also protect know-how like a trade secret, provided it's coded in a certain way, and your offices can help you in that. But Not all, but if your results are not patentable, so they have not the technical characteristics to be subject to a patent matter, they still are valuable resources that can be exploited in industrial application, and we'll see a little bit later on. Some protectable results could be composition of matter, like compounds, pharmaceutical composition, some materials, devices, even databases could be protected somehow. Also standards and standardization process, and then we will dig with Matthew about software and copyrights, which are a form of protection, but at the same time are treated a bit differently. And then the other key definition is what is a technology transfer office that your institution may also call business development office, industrial liaison office, or some sort of name like that. It's actually the office of your institution that is devoted to help you understand your innovation, how to protect it, how to help you exploit that innovation, and how to negotiate the agreements that better protect those innovation when you collaborate with your peers or when you collaborate with the industry. So every day you see results that are innovation that came out from researcher and institution, academic institution. And some are like the GPS, vitamin D fortified milk. But talking about rare diseases, the two first example of a very successful technology transfer process are perhaps Luxturna and Holoclair. The first one is an in vivo gene therapy that was developed by the Children's Hospital of Philadelphia, and then at the discovery stage, and then was licensed to Spark and commercialized by Spark Therapeutics and Novartis, depending on the geography. Closer to home for us is Holoclair, which was discovered by an Italian academic university, University of Modena and Reggio Emilia, and then spin-offed in an academic spin-off called Holostem. And this was the first cell therapy ever approved. What it takes to get there? Good science, of course, a bit of luck always help, but also a careful and process of technology transfer. So technology transfer is a process that support the research project and helps transforming results into some opportunities that could also be commercial, with the intended aim of if any financial gains or returns is made about a discovery, to reinvest those gains into furthering again research and discovery. So your technology transfer office can actually help you way before you can imagine, even at the stage of defining strategic aspects of your grants, if they are devoted to develop your results in a more industrial way, but also if you want to access materials that is available only at other institutions or at other industries. So it's really a process that helps you protect your results and the related intellectual property at 360. And they also help you protect those intellectual property through agreement. But when you start talking with your TTO, usually before you want to disseminate your results, this is very important, because to assess if there is a protection, a way to protect results, and use this protection as a leverage, these results shall never be public before. So before disseminating your research, like with an abstract, with a poster presentation or a manuscript, always talk with your technology transfer office and ask them if there is a way to protect your research results, like you discovered a new methods that could be then transformed into a software, you discover a new you invented, actually, you design a new construct for a gene editing approach. There could be anything. And what will happen is that your technology transfer office will understand with your help if these technologies are new, not obvious, if they are inventive in a way that is not obvious to your peers, And to judge that, actually, it means that nobody else talked about something like that in the literature or in other patents. And once you protect or, if possible, your research, your technology transfer office helps you in managing these results with your collaborators and eventually with your potential industrial partner. But it's very important also to understand when you want to use your results or you generate results in a collaboration, to understand if you will own these results or if they will be co-owned, if you will be free to use them and free to publish them, in addition to evaluating their protection. And now you can use those results in collaboration with others. We will make some example about that. But why assessing if these results can be patented and how to exploit this patent? The patent is a pact with the government. So basically, you are protecting in the negative your results. It means that by by filing a patent application, what you will get is that nobody else can do commercially that thing without your permission, which involves usually also gaining some economic returns for that. But why that is interesting also in rare diseases? Because in that way, for example, a new gene therapy for a rare diseases, if can be exclusively accessed only through licensing a patent, it gives a business competitive advantage to a potential industrial partner that will say, okay, if I invest a lot of money in developing this treatment, perhaps nobody else can use it if I have a patent, and therefore I will actually have an economic return that helps me pay back my investment. At the same time, by having this certificate of protection, the government actually allows dissemination of information because the patents is basically a pact by which you disseminate your information while still keeping a privileged commercial exploitation time period. So in high cost, high risk research field, this is very important because it gives you an edge in negotiating partnership to further develop and get proper visibility of your asset that otherwise would be considered weaker in the absence of the exclusivity of commercial potential. And at the same time, the patent, if you license it to an industrial partner, also allows you to well define what you can control in an industrial alliance. For example, if you license the patent to a partner on your technology and you do not sell it, you don't assign it to your partner, actually you can put in this license agreement some clauses that helps you retain ownership and get it back if the project doesn't meet certain development standards. So sometimes our researchers are very scared that patenting will delay their publication. That's not the case if you talk early with your TTO, and usually not after you have published. So this is the timing and the expenses associated with a patent. So more often than not, you also have economical issues in the academic field about patenting. But when you have your manuscript never published, never disseminated with your research results, and you talk with your TTO and you say, well, you decide with them that there is a space for protection, actually, you can basically file the patent while you submit your publication. And for a certain time, you will have 12 months in which you could also expand a bit the data. And I say that because sometimes researchers do not understand that in these 12 months, you do not have to, you can still expand your patent provided these data do not get public before adding them to the international extension of your application. Only after 18 months from when you find the patent, your patent became public and available also to others to be seen. And so beside your scientific publication, also your patent is public and it becomes of interest for potential investors or partners. But the patent is not, although the text of the patent is somehow fixed, it's not an object that you forget in a drawer. So it requires a bit of work from you and from your TTO in following its life and making sure that this patent really serves your project in terms of development. And remember that inventorship and authorship are not the same thing. So it could be that the paper you want to publish contains more authors than the inventors on the patent that cover the technology described in your paper, because an inventor is the individual that conceived or contributed some essential element of the invention, so of these research results, alone or with others. And this intellectual and creative input is what really gives you the inventorship of this asset. And normally, in most jurisdictions, it's your employer, so your institution that owns the title. It's like to say that you live in a house owned by your employer. So your patent is the property of your employee, but you are an inventor on this patent. But why do we need to patent? To get leverage and to then find partnership with the industry to better develop our project. And so what you usually do in collaboration with your TTO is they support you in identifying potential partners, and they help you also solve potential conflict of interest in interacting with them. We know that the industry is profit driven, even at the research stage, and has business constraints in what in the subject of their research, and they do limit public disclosure to maintain a sort of competitive advantage in their field. So the TTOs will help you negotiate relevant agreement. They will negotiate them for you to maintain the possibility for you to do curiosity-driven research and your academic freedom, and even publish or maintain certain open source access to certain resources, but at the same time protecting the interest of the project in developing, for example, a therapeutic. In this way, and you will see it later in the case studies, we propose in Fondazione Telethon, but this is a common way of approaching partnership in the industry. We always keep in mind certain pillars of the technology transfer between academia, making partnership between academia and the industry. The fact that you have a leverage with a patent to attract, for example, a potential pharmaceutical company that is able to further develop to the clinic a drug that you discovered. This partnership in any case has to safeguard the research independence, work in strict cooperation with the scientists during the project. And of course, you have to retain certain intellectual property rights. So you have leverage to maintain and constrain, to have control on the development of the project. And in case for commercial reason the partners fails or decide that abandon therapy development, you can take that IP back and co-develop the results to your institution. And of course, this partnership has to support the research and provide some later on, like funding and financial returns, like royalties, that can help support again the researchers and the institution. But this is a process that really goes hand in hand between your institution and the researchers in defining all the steps of this partnership, from the purpose to what do we give in this partnership and what do we get in this partnership, like access to competencies and resources. And your TTO can then guides you through the legalities and the due diligence of that. So the take-home message is that when you think about therapeutic or other potential development of your research, do not disclose before evaluating protection, and always contact your technology transfer office to discuss potential application. And I leave the stage to Matthew.
So hello everybody. So my name is Mathieu Collin. I am the head of intellectual property at Inserm Transfer. So I am a European patent attorney and I have experience of 20 years at Inserm. I'm more specialist in patent matters, but today I will give you some clue regarding the question of to protect a software. Why? Because innovation integrates more and more digital objects, and computer science is now a basic. It's basic in life science research, especially at Inserm. So just to make, so we can move to the next slide, please. So I will take control of my presentation. Okay. So just to make some link with the presentation, Barbara's presentation, just to remind you that European community aims to maximize the social and economic value of research and innovation in Europe in general. And the question of having a very efficient intellectual assets management could in fact make some leverage to innovate, make some creativity, and of course make some value at the end. So basically, regarding the question of software, the European Community acknowledged that this subject is very technical, and that on this aspect required a tailored approach to IP protection and enforcement. So regarding the consortium here, I would like to remind you that there are some provision regarding specifically the subject of software, and you have some provision regarding in the framework consortium agreement, but also there are some specific provision that are stipulated in the pillar 2 and 4 agreement, which is dedicated to the IT development of the consortium. So I will introduce to you the different way how we can protect a software. So when we discuss the subject of how protecting a software, of course, we will discuss about copyrights. Software copyright could cover and protect the specific code that you create and that is used in the program or elements in the user interface. So you can protect the code and elements that are displayed by the interface. I would like to insist on the fact that copyright is part of intellectual property and is automatically obtained by the creation of the work. So unlike with patents, there is no need to go through an application process to have the right on the code and the information that could be displayed on the user interface. So practically speaking, if someone in your lab comes up with a unique code for software, this code is automatically protected under the copyright law. So copyright is usually applicable to the duration of the copyright owner lives, plus 50 years. So we can have a very long and strong protection on the code regarding the fact that copyright can provide you to this project. So, but in different situations, you will probably need to organize the proof that you are in possession so you have the ownership of the software, and for that you can make some deposits to constitute this proof of ownership. And my recommendation is to do this deposit in different contexts, but my recommendation is to make a deposit before the work is published or commercialized in order to protect against possible usurpation by third parties. So for that, you can have a proof that you are the owner of the software. And probably also before any collaboration with a partner, industrial partner, that could materialize the existing background, especially regarding software, but also my recommendation is to perform a deposit if you are in the way to improve the software by establish different version of it and to make a link, a parentage between all the version of the same work. So you can organize this proof by different means. You can make some contact your notary and make this proof of ownership, but you have also some non-profit organization like Agence de Protection des Programmes in France, but it's open to in Europe in general. You can submit and deposit your software in a database, and you will have a certificate number that proves that you are the owner of the software. So software is a very good means to protect the software, but it only applies to the code that are generated by your researcher. And it will only protect you from misuse by third parties, but it will not protect you against parallel development by third parties. This means that if a third party develop a competing software product, so it will probably generate a different code, but it will at the end the software and the code will do the same, will achieve the same results than your software. So you can here by if you have some protection only based on the software, you will not be able to in fact avoid some competition regarding different software that could be created to do the same as for your software. So it can be very interesting in this context to imagine that you can file a patent application. Why patent application is interesting? Because it makes possible to seek a broader protection for software innovation by targeting, in fact, not the code, but the technical concept here. So it is possible to protect the inventions that are implemented by software using a patent, but this comes with a proviso that this invention must solve a technical problem. So I will not enter into the details here, but you have to comply with some criteria regarding the fact that you will apply for a patent. As Barbara said, you must meet different criteria, which is novelty, investor steps, and industrial application. In Europe, I would like just to stress that the European Patent Convention explicitly excludes a computer program per se, so it means that you cannot file a patent on the code, but more than on the method implemented by the code. So just to illustrate my position, I would like to introduce you an example, and for that I will jump to my browser screen. Okay, so it works. You can hear my screen?
Yes.
Yes, okay. So just to take an example, I would like to introduce this article. It's a very recent article published by the beginning of the year, and it's not focused on the rare disease. So I'm sorry for that, but I would like to choose an example that is the most illustrative possible. So here this paper discussed about machine learning driven virtual biopsy system for kidney transplant patients. So the context of this innovation comes from the fact that when you transplant a patient, you need to assess the quality of the transplanted organ. So for that, you need to perform a biopsy. And biopsy is an invasive method, so there are some risks, and it's also expensive. So the idea here was to investigate the opportunity to develop an algorithm that could, in fact, be implemented to have a virtual biopsy of the patient based on the use of some clinical parameters. And for that, you can, so that's the aim of the article, and they develop said algorithm. And just to illustrate the fact that it's how it works, so you can here, you have an interface that will display all the information regarding this virtual biopsy. Here you will be able to qualify the quality of your organ with a different parameter. For example, here, fibrosis, arteriosclerosis, etc. And you will be able to manage the patient in terms of how we can be sure that this organ will be, this transplant will be have a long expectancy of duration will be a stable organ transplantation. So I would like just to insist on the fact that here the algorithm is publicly available. If I'm not sure that you will be, so you are disconnected from the server, so I'm sorry for that. But I would like just to illustrate that here the virtual biopsy system is available to the public. So any clinician that would like to assess the quality of the organ can use this open algorithm. So I will revert. Oh, sorry, I make a mistake. So sorry for that, Yanis. You explained to me, but I did not return.
It's fine. It's
okay.
Fine.
So here we patent the method implemented by the algorithm, just to illustrate. So I put the publication number of this patent if you would like to have a glance at it. So here we have two different claims. One is related to the method implemented by the algorithm. To protect here a method for assessing at least one histological piece of information, and we specify that method is being computer implemented, and we describe here the different steps to achieve the results. And then after we have a second claim regarding the computer program itself that is implemented, that implements the method previously claimed. So here we are able to protect the method by itself, but also the computer program. And for that, we will be able to, in fact, avoid any competition regarding the development of this method. And in a business model perspective, we license the technology to a company. This company, in fact, will provide to the clinician some services. So, as I said, the software, the algorithm is publicly available. But here, the company will provide more and more services and will also provide some guides to the clinician to address how he can manage the patient after assessing the method. So for that, we can imagine a business model that is compatible with the fact that the algorithm is publicly available, but also to secure some business assets, so we can mix the two systems. So here, so I discussed about software copyrights, software patents, but we can also include other means to protect your software. And I will take control of my presentation again. We can, we can also be able to, when you have a software, you can think about protecting the graphical user interface. For that, you can apply for a design patent. So design patent is a type of patent that is granted to protect the unique visual characteristic of an invention. For example, you can protect the icon, the transition, the layout, the animation, etc. And for that, to be eligible for a design patent, you must go through an application asked for utility patents. And at the end, you have to justify that your invention must be new, original, and ornamental. So here, I would like just to inform you that the term of a design patent is 15 years from the date of the grant. And you have some famous design patents. I would like just to refer to the Apple iPhone, where is was the subject of some famous disputes between Apple and Samsung. So here you can use these tips to protect additional matters of your software here in the sense that you can protect the graphical user interface. But you also include some trademarks. So trademarks cannot be used to protect your invention or your code or the innovation that is implemented by the software, but it's a very strong tools to protect the name associated to the software, because the name can convey a lot of information, and you with the name there is a you can identify easily the nature of the technology, and for that it could be very interesting to protect your name of the software by filing trademarks. So trademarks law prevents a third party from using a commercial name which is confusing or similar to trademark of the software. So at the end, you could understand that a software can be protected by a combination of different intellectual property rights, so including copyright by itself, utility patent, as I said, design patent, trademarks. I did not discuss the fact you could also use some trade secrets to protect your innovation. But for that, for how you can define your strategy, I think that you must address some question, very important question. And this question can be, for example, what is the commercial value of my software? What is my strategy of dissemination that I would like to associate with my software? For example, I would like, the question is, for example, open for science and research, but you will make some restriction for commercial uses. Of course, intellectual property could be very expensive. So the question is, will be, what is my budget for that? And next question will also be what is the pressure of copy? Because if you have a high pressure of copy, you need to be protected very strong in a strong manner. So you need to be very aggressive in terms of intellectual property, but also you have to ask for some of the basic questions. So in terms of what are my expectations in terms of financial returns, and so another important question is also my ability to identify infringement. If you are not in position to identify infringement, you are probably your IP rights will not be very useful. So in my opinion, and probably my take-home message, I would like just to insist on the fact, if you think that your software could have a commercial value, my recommendation is that you need to organize the proof of ownership by make some legal deposit before a notary of a non-profit organization, as I mentioned here for the Agence Protection de Programme. But my recommendation also is to investigate the opportunity to file a patent application. By combining these two means, you will be able to protect your software in a strong manner. So in my last slide, I would like just to open a very important question, and say how to reconcile open source and IP rights. So at first glance, and usually we think that open source software and IP rights are not compatible. This is not true, in fact, but it's required some very, but it's not a very question to manipulate, but you have to anticipate about how you can reconcile, in fact, your strategy if you would like to go to open source software on IP rights. For example, it is possible to support open source while maintaining an active IP program. And you have different models for that, but one very common model is to have an hybrid model wherein you can release certain software components as open source while keeping other ones as a proprietary software. So my recommendation is that you need to adapt the best practices. For example, if you would like to integrate an open source software dissemination, I think that you should clearly you choose a license for that. And it's very important to establish said clear license policy, because the license will, of course, organize how the software can be used by third party. For that, there is plenty of license that you could use, but you are also be able to customize your own license. For that, for example, at Instant Transfer, we develop our own license to allow the researcher to distribute, disseminate software for open in an open manner for basic science, but we restrain the use of the software for commercial purpose. At the end, also, if you also want to follow an open source strategy, you have my recommendation also to conduct some review before giving access to your code, because you need to control that your software will not be able to infringe some other third-party rights in terms of copyright, of course, but also in terms of in terms of patents. So open source and IP rights is a very complicated question, but you have to anticipate, and I recommend you to read a report that is accessible from the UC, and I provide you here the link to get more information about how we can manage these two types of rights. So I would like just to thank you for your attention, and I think that we'll jump now to Q&A questions.
And before, we are having one quiz. So
okay.
We wanted to test if you have followed carefully and understood everything. So we invite you to participate to this short quiz of 3 questions. You have the QR code that you can scan, or you can click on the link that I have put back in the chat, or connect to menti.com and use that.
Yanis, we do not see the slide with the QR code.
You do not see the slide yet. Thanks, Julian. Taking over. And here it is. I will leave you 30 seconds to connect. Okay, sharing my screen. So it's about IP strategy for software. And all right, 38 players ready, 39, 10 more seconds. Of course, the fastest answer gets the more points. And Mathieu, maybe you want to...
So the first question, it is necessary to go through an application process for copyright? The response is yes. A formal deposit is mandatory, or no, the copyright is automatically obtained. So it's a creation of original work.
Okay, so it's mitigated half-half. So the good answer is that no, the copyright is automatically obtained
Yes.
as soon as there is a creation of an original work on it.
So the deposit here is only needed for organizing the proof that you are the owner of the copyright.
Going to the next questions, and the number of players increased. So
the next question, what is the time range for copyright? So the first answer is 20 years, and the second answer is the minimum of 50 years after the author days.
And considering the longevity of human beings, it can be long. And yeah.
But it doesn't make very sense in terms for copyrights software. Development are very, very fast. I think that's
true.
So here the response is a minimum of 50 years.
And the last question for this session.
Can we combine copyright with patent right to protect the software? So first response, yes, the copyright protects code. Patents can protect the invention implemented by the code. And the second answer is no, software is excluded from patentability.
Okay, great. So, much better score here.
Yeah.
So indeed.
Okay.
Super. Moving forward with the question and answers that were submitted in the other Mentimeter, we did not receive too many questions. Up to now, we received only one question. So it's for you, Mathieu, regarding open source software and licenses. What would be the added benefit of using an adapted license versus the existing ones? And in this case, should we discuss the changes with a legal aid?
Alors, so adapted your own license to customize your license can be provide you some advantages because, for example, the first one will be your license need to be compatible with the national law and plenty of licenses that are available are only compatible with the US law and not, for example, European law in general. So you have to take care about this. And it could also be some advantages because you could, in fact, if you customize the license, you customize the rights that you would like to disseminate regarding the object. So it could be a very interesting, but there is, as I said, plenty of licenses. You may also go through this bibliothèque and to choose the most appropriate one for your project. But I think that you could, of course, be benefit of the help of your legal team to adapt or choose the license.
And we received no further questions so far, neither on the chat or on the Mentimeter.
we can
move forward with the
move
presentation.
forward perhaps.
Yes.
Or we can wait a couple of more minutes to see. We probably will have more questions later on in the
Indeed.
where we touch more practical point. So
it will be the same Mentimeter that is pinned on the chat. I will put back the link to the question and answer Mentimeter so that you can submit your question all along. And then we have the same Mentimeter for other quiz.
I just shared it, Jens.
Thank you, Julian.
okay, can you confirm that the presentation is showing all right?
Yes.
Yes, okay,
Yeah.
thank you. So as I anticipated before, this will be the most boring part of the presentation, in the sense that much of the work we have been doing within EJP in respect on with respect to promoting awareness on result protection, copyright software relates to an H2020 grant, that is EJPRD, that has specific rules for the management of the results that are generated, of the background of the party that is contributed to the project. Therefore, also in order later on to make some, let's say, case study or mock study as exercises and example to address all the topics we really broadly talk about up to now, we also need some to put some definition and specifics to work that are related to the specific provision of the European Union grant. So, of course, since we are referring to EJPRD, we are talking about Horizon 2020 framework of grants rules and regulation. They are not so much different from the most recent one, like Horizon Europe. So they could also apply, but please, if you have an Horizon Europe or a later grant, please check then the specifics. So what happens when you decide to set up a collaborative projects in general? You have some background that are all the methods, the know-how, the materials, your published and unpublished results and discoveries, and perhaps also some patents that poses the basis to further develop research in collaboration with other of your peers, scientists, and you decide to write a grant application that then is funded. And on the basis of the background of all the parties, you will generate results. That could be a mixture of improvement on different backgrounds or something totally new. When you are funded by an agency in order to conduct your research and generate results, that agency could put some rules in what you can do or what strings they are attaching to the results you generate within that action. The European Union actually does not have so much strings attached. For example, the European Union funds do not allow the European Union itself to have the property of your results. It may happen in some other cases. But we are going to analyze which are the rules for participation and how they impact what you do with your background and your results within a European project. So what happens? Because of the European Union grants that you are awarded with your collaborators, you actually accept some condition with respect to the access you give to the background you bring to the project, and the access you give to the results you contribute to the project, and the access you get on the results of the other partners of the project. This is a way for the European Union to promote the exchange of research and results, the dissemination within collaboration to promote further development on existing science. So, so it is really it is useful to understand how these work. So if you contribute a background because it put the basis for the research that you want to conduct, this background has a specific definition and is what you need to implement this project. But bringing that background, it needs to be accessible also to your partners that generates results with you working on that background. And at the same time, you need the access to the background of the other partners in order to conduct your collaborative research with them. At the same time, when you generate results within a European grant, you are implicitly also giving access to those results to other parties to conduct research, to use their results for further research, and potentially also for exploiting their own results. And we will go deeper in that in a while. These strings attached, let's call them like that, are very well regulated and defined through a series of documents. And in particular, for Horizon 2020, they stem from the rules and regulation for participation to the European grant. We are not going to dive too much into that, but these rules and regulation have the aim to promote research, innovative research, but especially the exploitation of that innovation. So it is a requirement for a European Union grant to evaluate the potential for protection and exploitation of the results that are generated in a way that is strategic also to the European Union. In certain disciplines, the European Union could also step and somehow force the protection and the for exploitation or the dissemination of certain results, like during the pandemic, for example. In order to implement such rules and regulations, there are some specific definitions. So when we talk about background in a European Union grant, it means data, know-how, or results obtained before the project that are under the control of that participant before joining the project, so before winning the grant, that are needed to carry on that project, and that has to be identified in a specific legal document, that is the consortium agreement, according to the rules. So the background is explicit and it is agreed by the party in the consortium agreement. So each partner will list their background that is needed in order to conduct the project. It can be needed only by that partner, or it can be needed also by the collaborators in order to do further innovation. At the same time, also the results have the word results have a very specific meaning in European grants, and under these H2020 rules and regulation, it means any tangible action or intangible output of the specific project, from data, knowledge, information, or methods, whether or not it can be protected. Results so covers all the results generated, and if these results are protected by a copyright, a patent, or other means of intellectual property rights, this definition extends to those rights. These rules also define what the dissemination is, abstracts, poster, thesis, and how it can be promoted, but without damaging the evaluation of the protection through patents or other intellectual property rights of your results, so to maximize the chance for the exploitation. It is one of the hot topics for the European community, especially in the subsequent action like Horizon Europe and the subsequent frameworks of funding. Exploitation can mean two things under a European Union grant. It means further research activity that are conducted in the academic setting, or the commercial exploitation of a specific product that comes out of a project, or a service, or a standardization activities, so that has a commercial potential and the potential to generate revenues, let's say. Since access rights for commercial exploitation are regulated, they are regulated under fair and reasonable condition. That means the appropriate condition, including economic terms or free terms, by which you get access to the background or the results of other partners, or other partners can ask access to you, to your background and to your results. Fair and reasonable condition means that it has to be, if it's an economic value, market value, not in, how do you say, unreasonable or unreasonable economic terms. That is a way to say no to the other party to their request for access. So these rules for participation are very broad. Then they are condensated in a more detailed way in the grant agreement, that is the document that all the participants sign when they are granted a European funds. But then still, as we will see, these rules are converted in some sort of procedures, but which are very broad. So in the day-by-day implementation of the project, there is another document that is very useful to understand how to implement this provision regarding background, results, and what you can do with both. That is the consortium agreement. So we are always referring to the H2020 template and the EJP RD as a specific case. So the definition we saw are then implemented in how the grant agreement binds the partners to observe certain obligations in terms of what they can do with their background and the background of the partners, with their results, and how to manage these results if they are jointly owned with other participants, how to exploit them, how to transfer them, how to license them. So the major takeaway is that the parties should agree on the background that is in the consortium agreement later on, and they have to list it, because it is very, at the moment you put a background in your background, that it could be know-how, methods, it could be some specific patents, some specific technology that is protected by a patent, a snippet of code, a piece of software. All the partners agree to put the background needed for that specific action. But what you will need to do is that it has to be very clear and defined. And you have access right to that background. It means that if another partner needs your piece of code or your material to implement their action that you planned in the grant proposal, you need to give access to them to that material or that proposal through a proper agreement. And it should be, of course, for free for the implementation of the action. If there are some reason for which you cannot give access to your background, you have to list them. List them in the contract, and we will deep a bit later on. So what do you do? So you have to inform through the consortium agreement that this access to background is limited or has certain strings attached. Or, for example, that you can give it for free only for research, and it will be available only under fair and reasonable condition, and not for free for any other use. But this information needs to be clear up front. If you have to change the background or remove access to your background, it requires a decision that involves all the partners of the consortium in which you are involved. You cannot take out background from a project without the consent of your partners. This is the same, but for the economic exploitation. When you implement results of the action, what happens? You may generate results alone, or you may generate them in collaboration with your peers. So you have to establish who owns these results. And while it's maybe very clear when you own your own results because you did the work alone using only your background without any other input, it could be easy to understand that this piece of work is only yours and of your institution. When you collaborate, the results of that collaboration, that could be a software, that could be the construct for a new gene editing approach, for example, it will have pieces of the new work of all the partners and perhaps pieces of the background of the partners that worked on that specific activity. And so you have to define the joint ownership, and there are rules to follow. And the grant agreement gives you a scheme in order to understand how to assign the joint ownership. Usually it's assigned under inventive contribution, or if this cannot be assessed, it's split equally among the parties. And the grant agreement provides for and let's say warmly recommend that the partner that generated a collaborative results then implement agreements in order to have clear guidelines in what each partner can do with the results that they co-own. In particularly in terms of exploiting those results. It's like having in co-ownership a house. When do you go on vacation? Do you want to be all together at the same time, or do you split the time? You cannot sell a house that you co-own without the consent of the other partners. You cannot rent it without the consent of the other partners. And I know the it's not perhaps a good fit, but it gives you an idea of what you can and you cannot do with a property that is co-owned, because it applies in a general sense also to the results and the intellectual property that relates to those results. Regarding results, we have, when we participate in a European grant, an obligation to protect those results, and an obligation for each beneficiary to assess if there is a way to protect those results, software or a patent. Of course, if there is a commercial value to that protection. In certain grants, if somehow all these criteria are met, so your technology is patentable, there is commercial value, but you still don't want to patent, you may need to notify the European Union that you don't want to do so, and they may decide if let go of this protection or assume at their expenses the protection of those results. This is a rights that the European Union keep on the results generated through their grants. The exploitation of results is defined in order to understand what is meant by this word, and so how to regulate the access right for exploitation. So when results are generated, all the partners have the access right to have the right to ask for access rights to those results because they want to use it in further research activities outside the action. I see a question on the Mentimeter, Yanis. I mean, about...
We will be answering them during the Q&A session. So
no, that they cannot use the Mentimeter. They are asking to open it again.
Right. Yes, okay, thanks.
So, the definition of exploitation helps us understanding what the European Union means with access right. So there are results generated, and what you can do is ask for access right to your partner because you want to develop other research outside the action, because if you need them to implement the action, that is a granted right. So you have they have to give you the access to implement your activity under the project. If you want to do something else, you need to ask for access right. And then you can also ask for access right for commercial reason if the results of another partner are needed for you to be able to commercially exploit your own results or provide a service with your own results. Of course, the access right is not meant to subtract results to the owner of those inventions. Dissemination is very welcome, even in an open access, provided that it does not impede the protection of the results and their exploitation. And there are provisions to ensure that all the partners are aware that they have to assess if there is a sense, a rationale to protect and then exploit their results, and only after assessing this protection and protecting the results through the proper intellectual property certificate, they can disseminate their results. Given these strings attached, the rules for participation and the grant agreements tells you also what you can do with your results. So even if you are the sole owner of the results, so nobody else helped you reach those innovation, you are of course entitled to transfer the ownership, that is, sell or assign these results to somebody else, some other entity. Or even license them, even exclusively. But since by accepting the European Union grant, you are accepting all the strings attached to access right, you can do this transfer and licensing of your own results if and only if those access rights are maintained even through the transfer or the licensing. Another option is that you ask all your partners in the project to waive, so to renounce, to abandon their access right in writing, so that you can license and transfer without attaching those access rights to the contracts by which you transfer or license those results to your, I don't know, industrial partners, for example. If the results are co-owned, the European Union expects that you have agreed on a interinstitutional agreement, a managing agreement of the innovation that you co-own with other partners. And so there are guidelines, minimum guidelines in how to deal with the transfer of ownership and licensing. But as I said, when you co-own something, you have first to notify and get the permission from the other co-owners in licensing the results. How much do these access right to results and background last? They last, at least in Horizon 2020, for this specific grant, at least 1 year after the conclusion of the grant. So up to 1 year after the expiration of the grant, you still have the possibility to ask for access rights to your partner results and vice versa. When you get access rights to your partner's results or background for your use, what is granted by the European Union is a basic license that you cannot resub-license to other people. You can only use it yourself unless you have a specific agreement with your partner. So all these propositions are then a bit more implemented in terms of timings, type of communication, etc., within the consortium agreement, where you also list your background and all your other partners list their background with all the limitations associated with their background. For example, it's not accessible for commercial use, is not accessible to be used outside your premises. Sometimes, for example, it may sound strange because if you are in a collaboration, you think that if you have to work on a material with a collaborator, you need to transfer that material. It may be the case, or it may be that you find another way to work around. For example, sometimes we have partners that collected human samples, but with the agreement by which they collected human samples to be used in a research project, they can only use it under their premises. So the research on those samples will happen only in their institution, and they cannot be transferred to other partners. And this is a background that is excluded from access because they have no rights to transfer to anybody else. This is one of the examples. Specifically for EJPRD, since the project is very complex, we have tailored consortium agreements. So, of course, we have a frame consortium agreement that follow the standard DESCA model, which you can find, I think, on the IPR help desk. It shapes the partnership among the beneficiary, also in terms of how many times we meet during the year, etc. And provides the mechanism by which the rules we saw before of the grant agreement are implemented in the day-by-day practice. But since the large work on the virtual platform, that is a very complex software work, and not only software, but let's say one of the main activity is related to software development. We also design a consortium agreement that depends from on the framework consortium agreement, but is specifically focused for the participant in those activities, and assess specifically data ownership and data access management, and software ownership and software access management. In particular, I just listed here some of the critical issue. So actually, let's say that in the DESCA model, the software provision, which there are some standard clauses that reflect what is provided for in the grant agreement and in the rules for participation. So these software provisions helps you navigating how to manage the softwares, the source code, the object code, etc. In your collaboration, but always applying the same framework of results and background definition and access to results and background. For example, in this specific case, there were two definitions that were used. One, the source code, that is, and one is the object code. And so in order to have a little bit of distinction, because sometimes you don't need the entire source, the real source code to from a partner to implement your own activity. These object code could be sufficient, and so sometimes it could be the only thing you have access to. But at the same time, the source code could be needed in order for a partner to implement specifically their activity, and so also access to the source code is granted in the same way access rights to background and results is granted during the action. Why the distinction? Because the source code is something precious that not always, as Matteo told, is sometimes you don't want to be too transparent about it in order to have a bit of leverage in exploiting the software you made from the source code. At the same time, in this particular activity, we didn't want to prevent the people working on the different part of the virtual platform to be stuck because they didn't have access to specific source codes. So if we want to make another more concrete example, imagine, for example, that you are in a project in which there is the need to encapsulate a drug in a new formulation. You may receive from your partner the drug already formulated, and then you test it in your animal disease model and you go on development. But if you want to go on development, it may be that you also need to understand which was the composition of that formulation. At the beginning, you may not need it, but afterwards you may need it, and so you want to have access to that. Being a background, it will have its limitation, if it has any, or it could be freely accessible, but you will have to make a request, and the partner will have to comply according to the regulation and the grant agreement. So take-home messages. Identify the background needed, and if you know that there are strings attached, like it's not your material, it's a commercially available, that sometimes comes with a license from the provider, or you have patented already those background, talk with your TTO. They will help you in framing the inclusion of the background. And then you can map the contribution to the results. Remember your lab book, your proof of activity, and remember to define agreement for the management of the joint ownership results. They will also help you in managing access right. And I'm done for this part. So it's not yet time for the break, it's time for the Q&A actually. Okay, they are all sleeping, waiting for the coffee.
Indeed, so we do not see yet question and answers that are posted. And maybe we invite the participants, because we have a little bit time, to raise their hand, comment, or ask specific questions. So you will be granted access as a presenter. Do not hesitate to raise your hand. Okay, so.
Oh, thank you. I see you as unknown user, but thank you for the support.
Yol, please go ahead. You can unmute and share your camera if you want.
Great. Thank you so much for this presentation. So I'm involved in a project, in a natural history project. Basically, we're not creating something that can be patented, but we hopefully will generate data that can be potentially used by commercial by pharma companies. So my question is if there are any different guidelines pertaining to data in comparison to patents. Like ideally, the data from our project will be freely accessible to pharma companies. At the same time, we have our universities and the different members in the consortium, which tell us that anything produced in the project, including data, is in order to for pharma to get commercial use, there will need to be some negotiations, and it will cost pharma money. So I'll be happy for any comment on that.
I can start then, Matteo, if you have some specific comment, please jump in. So I think that data is the new gold or the new petrol, if you like, both because of artificial intelligence, investment nowadays from any kind of company which relies on personal data. With respect to clinical data, they are even more precious, especially to pharma company, and especially in rare diseases, I would say, because natural history studies, well done and well conducted, are an invaluable source of information. And that's something that, even if it's not patentable per se, is very exploitable. And there is a reasoning behind your institution in terms of having some money to fund the maintenance of those data, for example, or other follow-up or other type of research. So don't think as the commercial exploitation by the university as just for profit. Is of course for funding other resources. In our experience, we have two themes associated with that. On one side, if you are conducting a non-profit clinical trial, you may not patent or profit directly from those data. It depends on the jurisdiction. You may have some rules that apply to that. But when you can, or by converting to a for-profit agreement or other strategy, there can be many options. Usually when you publish, you not necessarily publish the raw data of the trial, but a publication that comprehensively analyzes those data. Sometimes the company want to have access to a registry, for example. So a way to exploit that could be, so a natural history study may involve gathering data, but it's not the same things as establishing a registry, which has different type of requirement, and therefore one option could be that you sign partnership to, for example, that finance the creation of those registries and give a preferential access to the funding companies, and then a public access later on. It could be, for example, a time-restricted exclusivity in for money, let's say. There has been an initiative in England, in the United Kingdom, in which they recently established one of the largest data set of human health data, and it was made through the contribution of certain pharma companies that had an exclusive anticipated access before public access to that large data set. It can also be that that data set is available for free if you are an academic institution, but for any commercial use, you have to ask for a license to those data. There are also some specific provision to how you protect data and databases. There are some indication on that. I'm not particularly expert on those that specifically apply to databases. I don't know if, Matthew, you have some insights, but there are some specifics that your institution can how do you say, understand better with a legal counsel that is expert in such IP rights. But there are many options that you can do. Many of those options depends also on the consent you have on those data, if they are pseudonymized or if they are anonymized, because unfortunately there are not there is a lot of discussion in simplifying GDPR for research samples, but not yet a unified simplification for all geography, let's say. I hope I gave you a, but if you have any other specific, please ask.
Thank you very much.
I think that your response was very complete, Baba.
We do not have any other raised hand. Stefano.
Hi, Yanis.
Hello.
Can you see me? Can you hear me?
We can hear you, and now we can see you.
Very good. Thanks.
Stefano, maybe you can provide a short introduction.
Yeah, I'll introduce myself. Yes. Meanwhile, you open the slide.
Yeah,
yes,
exactly.
right?
I'll be sure.
Okay.
Yes.
So I'm Stefano Benvenuti. I'm the head of public affairs and market access at Fondazione Telethon. Well, you know Fondazione Telethon. I've been involved in the EJP RD since the very beginning, but fortunately then Barbara took over. She's more expert than I am in these issues. But today I'm here to talk to you about an history of what happened with one of the therapies that were developed in the Institute for Genetic Therapies in Milan. This is the San Raffaele Institute for Genetic Therapies. Is an institute that is funded by San Raffaele and Telethon together. That has been working on rare genetic disease with gene therapy approach since the mid-90s, so 1995. So I'll go straight into the topic of today. So you probably have heard this story already. So I hope I will give you some additional inputs and hints respect to what you've already heard about. So this story begins in 2000. In September, a child affected by ADA-SHID was treated with this ex vivo gene therapy that, as I mentioned, was developed at SRTGET. And since then, the patient's been doing well, and today she is 24 years old. What's interesting is that ADHD is a very rare condition. We can easily say it's an ultra-rare condition that affects the immune system. So basically, because of a lack of an enzyme due to the mutation in this gene, I can't see the presentation anymore, but it doesn't matter. Due to the deficiency of this enzyme, basically the immune system is not working, I would say, at all, or almost at all. So any infections could be lethal for these kids. And that's why this disease is also called the bubble boy disease, because the kids needs to live in a sterile environment to avoid any possible infection. So this kid was treated in 2000, and then a couple more were treated in the following years. And at some point, Fondazione Telethon realized that this therapy was working, and we need to make it available to all patients. And the only way we knew at that time to make it available to all patients was to register that as a therapy. So go through the centralized authorization by the European Medicine Agency, which was not obvious for a not-for-profit and academia as Telethon. And so what happened was that we found a partner for developing that therapy and make it a real drug and not just an investigational product. And the company at that time we found was GSK, GlaxoSmithKline. And so in 2010, we signed an agreement with GlaxoSmithKline for the development and commercialization of this therapy. So an ex vivo gene therapy for ADHD. Here, I would like to give you some information about this agreement, because we're talking about IP today. We're talking about valorization of the IP, how to sign, out-license it possibly. And so I will go a bit more in detail into this. I'm sorry that this plus somehow is something wrong, at least in my visualization, but the concepts are there. So what is interesting is that at that time, ADHD therapy had no patent protection, because when Telethon started developing that therapy, we were really a bit, not so expert yet, I would say, in valorization. And so nobody really thought that, well, better protect this. It was a very innovative and experimental therapy back in 2000. And so it was just done and published. And so there was no patent on that. But we had the orphan drug designation that, as you know, gives the owner 10 years of market exclusivity once on the market. So it's not a patent protection, but still is something that is valuable or considered valuable could be considered valuable by industry. Then, second point, it was not only that therapy. I think this is crucial because for how rare that disease is, there is no probably, and we will see this later on, it's very difficult to build a solid business case based only on that therapy. But what was interesting for the company is that within the institute, that therapy was really the first of a bunch of therapies based on the same platform for ex vivo gene therapy. And among the various indications, one that was already under development was beta thalassemia, which is still a rare disease, but not as rare. So that was becoming something interesting for the industry, because they saw the potential of developing multiple therapies in this partnership. Then another key aspect is that the financial risk was shared. So we did not ask the company to pay in advance all the development. We asked for an upfront payment that allows us to cover some of the expenditures, and then we had milestone payments as far as the development of the various programs progress. So the risk was mitigated by the fact that the company was paying only when they saw the result. And I think this was also very useful on our side to keep track of the development and be always the one leading the scientific part of the development, because the development was done within the institute. Plus, again, on the financial risk, because the first indications were rare diseases, some of them really ultra rare, they already plan to have small number in clinical trials, which means that, well, apart from the development cost, the CMC cost, but once in the clinic, the cost will not be that high. And I think probably this is the key of the whole deal. The science was really innovative. Back in 2010, that was one of the first gene therapy coming really to show the efficacy in human with long-term follow-up data, because as mentioned, the first patient was treated in 2000. So in 2010, we already had some long-term follow-up data. And so GSK wanted to acquire the knowledge in the field of gene therapy, specifically in the vector production cell manipulation. And so they thought that was a good opportunity to learn from one of the most advanced institute in that space. And so this is how the partnership began, and the result of this partnership was very, very positive, because in 2016, Strimvelis became the first ex vivo gene therapy approved in the EU. Again, it's really important to stress it was the first, not just because we're very glad that we were the first, but because it means that the science behind that was really innovative. It's a gamma retroviral vector-based ex vivo gene therapy. And the indication is for the patients who cannot be treated by a bone marrow transplant because they do not have a suitable match-related donor. This is the key. I want to underline this indication because, as I mentioned previously, ADHD is an ultra-rare disease. Plus, the indication is not for all patients with affected by ADHD, but only those who cannot get access to a match-related donor for bone marrow transplant, which means that the patients that are targeted by this therapy are a subset of the already small number of ADHD patients. So in 2017, GlaxoSmithKline announced its plan to exit the rare disease space. And so because of a change in their strategy, they changed the CEO, and the CEO changed the strategy, and they exit all the rare disease programs. And so they innovate the agreement they had with us to Orchard Therapeutics. So a biotech, smaller biotech that was trying to developing gene therapies for rare disease, were much more focused on that. And so they were glad to take up this program. Basically, at that time, when GSK passed that, our agreement, Novate, our agreement to Orchard, we checked out, and the products within the agreement we had with GSK, so our products, let's say, were more than half of the pipeline of Orchard Therapeutics. So it was a big deal for them. But after some year, and here I recall you what I just said, that the disease is ultra rare, and the subset of patients that can be treated with this product is a subset of the patients. Orchard informed its shareholders that it will discontinue the investment in programs in rare primary immune deficiencies, and among them also the ex vivo gene therapy for ADHD. So at that point, we had to decide what to do. And the decision was really, sorry, something wrong, okay. The decision was to take over the responsibility for distributing the therapy. But we could do that because within the license agreement we signed with GSK, we had the so-called return back clause. So return back clause, it's a clause within the contract that says basically that if you stop developing the product or stop distributing the product, you should return back to us. But some key aspects of this return back clause that I want to highlight is, well, the trigger. What's the trigger of the return back clause? The trigger is that there were two triggers, basically. One is in case the approach was not mature enough. And so there was a need to go back to basic science, basic research. In that case, the company could decide to give us back the thing. And that happened for other indications, not for ADHD, as shown. It was working, it was approved, it was on the market. And the second trigger was the change in the strategy of the company, which is exactly the case that happened with Orchard Therapeutics deciding to invest from primary immune deficiency. So this is what triggers the return back clause. Then what are the enablers? So what really made us capable of taking back that program? Because it's not just the fact that you are allowed to take it back, but you should also be able to take it back. And especially for a program like this one, which is really advanced, was already on the market, was not obvious. So the first enabler, which is, I think, really a key, a cornerstone in all our agreements, not just this one with the company, is that we never sold out the patent or the IP we have on the product, but we exclusively we only out-license them with exclusivity, sub-licensing rights, so the company can act as if they were the owner, but they are not the owner. And so this gives us a big leverage, of course. The second is that the partnership was designed in a way that there was a joint governance. And so we were always informed and part of the decisions on the development of the program. So we were not passive in that sense. We were active, we were sitting at a table, we were giving providing our expertise on products and disease. Well, of course, GSK was providing the expertise on CMC and product development, but because we were there, we learned a lot from the company. And as said, because the development happened within the institute, we were fully aware of all the product characteristics, all the complexities. We were really into this business, and we also developed during the partnership internal expertise on regulatory aspects, on legal paths for access of patient cross-border, on CMC aspects. So we learned a lot from the company, and we built internal expertise alongside the development with the company in the agreement. And so the outcome of this return back clause is that all background IP was returned to Fondazione Telethon. But more than that, and this is another key aspect of this return back clause, is that all data and documents produced during the collaboration were also given back to Fondazione Telethon. So we have the full package back. And that's another key aspect, because of course, if we want to bring forward a program and you have been in an agreement in co-development with the company for many years, at some point, if something goes wrong, you don't want to restart from where you were before your alliance. You want to start from where you are at the moment the alliance ends. So what happened after is that in May 2023, Fondazione Telethon submitted the official request to the agency to be transferred the marketing authorization for this therapy. And here I want to highlight a point. It took 1 year to Fondazione Telethon to get ready for becoming a marketing authorization holder. So despite what I said before, that we were already developing internal capabilities to do part of the job and so on and so forth, we were not really ready to be marketing authorization holder. So it took us almost 1 year to be ready for that step. Some of the key things we have done in that year was to change our statute. We are a not-for-profit, and our statute said that we were created and funded to fund research, not to distribute drugs. So we had to change our statute to include also this other aspect, which is strictly in line with our mission. Our mission is to develop therapies for rare disease patients. So, of course, distributing the therapies we have developed is in the mission, but it was not listed as one of the things we could do. We had to reorganize our structure and to recruit new staff, pharmacovigilance, medical affairs, so all those functions that were not typical for us before. We had to negotiate a termination agreement with Orchard Therapeutics, and I will go back to this. So I said there was a return back clause but that doesn't mean that everything was automatic. We had to sit at a table and negotiate again. And then we had to innovate or renegotiate all the supply contracts with the manufacturing side for the product and all the other suppliers that OTL has. So all the things that are supposed to be done by a marketing authorization holder that were already done by Orchard, till that point, we had to take over. So not only the manufacturing of the drug product, but also all the CROs that were needed for the for conducting the post-approval studies and so on and so forth. And so we come to the end of the story. In June 2023, the European Medicine Agency accepted and gave a positive opinion for the transfer of the marketing authorization. So they assessed our internal reorganization, they assessed our structure, they said, well, you have all what it takes to keep this product on the market. And in July, there was a decision by the European Commission to approve this transfer. So Fondazione Telethon became responsible for providing the therapy to all eligible patients within the European Union. And with that, I just want to give you a last message. The take-home message from my presentation is that, and I quote the words of the former director of business development at Telethon, the one that negotiated that agreement with GSK back in 2010, a partnership is like a marriage. Be prepared to divorce. And divorce is not without pain.
We tried to collect some case studies. The first one is real, the other two are mock, to give you an idea of the thought process behind assessing intellectual property and how to develop it. So you heard by Stefano that at the very beginning, almost 24 years ago, we had this gene therapy that was proven in clinical, but we didn't pursue patent protection. Later on, we had a different approach to development. So I wanted to show you how one of the other institutes we fund and manage, the TGM Institute, worked in developing therapeutics for a rare eye disease. And everything starts, of course, with basic research at a very discovery stage funded by Telethon, but also by European Union grant. I'm sorry, I think there is one. Okay. And but at that time, we were a bit more aware of the leverage that intellectual property protection can give you in establishing an industrial partnership and being more appealing to an industrial partner. Also, the experience in the scientific endeavor behind Stringvelis helped us in understanding how much of the industrial expertise is needed to bring a therapeutic in human and then on the market. So here is just to show you that publication and patent protection goes hand in hand. So our researchers thought to have a first therapeutic approach worth of assessment, and we timed the protection with the publication in which he exposed to his peer scientist his approach. However, the discovery process was still ongoing and he perfected the technique, so that actually later on we actually abandoned the first patent because it was no more useful to the project the scientists had in mind, and he actually developed a platform. This goes along what Stefano said before. So what he did is that he was studying a specific disease, among others, affecting the retina, but this scientist envisioned the possibility to have a technology that could be applied to multiple diseases in order to solve other medical need. And actually, he developed also an alternative platform to address the technical issue that prevented the first one to work in other indication. And while research went on, thanks to also European Union grant, for example, and also proof of concept grants that allowed us to better define the value proposition to expose this technology to potential industrial partner, and to better manage IP with the collaborators of larger grants and the access to the material and the technologies needed in collaborative grant. You see, almost 15 years passed from the very beginning and the very inception of the research of this scientist. And through the good value of the science, the fact that we had an alternative two platforms that solved the specific need in this specific indication for eye disease, we also accompanied that with the orphan drug indication for certain specific indication, and that allowed us to explore and also sign collaboration with the industry that further advanced the technical development behind the two platforms. Then sometimes you need to be prepared to divorce, like Stefano said. So the first partnership was very stimulating. It was designed, as we heard before, in order to have a contribution by Telethon, not only in the research part, but also in the development. The company had an option to get a license on the technology, on the background technology, on the one developed under this partnership, but at the end, for commercial reasons, didn't want to pursue further. So we got back our background and the IP developed during the partnership, and we continue development until we then establish a partner with a venture capital and spin off the asset. Of course, these are very peculiar. This can happen also in academia. In our case, it's a very peculiar settings because besides the business development office, the technology transfer office, we can also reach out to other functions in our foundations that help us define the partnership and define first the project and the partnership that is needed from the project. So on one side, throughout this journey with the scientist, we carefully supported him in understanding the requirement of granting agency and of the collaboration, signing all the agreements with providers and academic partners, and the agreements with the potential industrial partners, in order to protect the access to the results that was needed for further development of the therapeutic approach. And of course, we were helped by all the functions in our institution, including not only the research and development, but also clinical operation, control manufacturing capabilities, regulatory affairs, translational project managers, and these are all functions that helps in sustaining a long-term partnership. But also these can, and in our cases, Fondazione Telethon balances these function internally. In other cases where the academia may not have all these functions available internally, they can also be provided by the industrial partner, while maintaining a little bit of control on how the partnership's going through, for example, steering committee that involves the academic partner within the agreement with the company. And if you don't have questions now, with Yanis, we thought about two practical cases that are mock cases with some questions and quizzes to try to put your experience into perspective. So, disclaimer, each case and each technology must be evaluated on its own, of course, but usually when scientists come to us, they say, okay, I think I got something interesting out of this research. What shall I do? And what will you do? Yanis?
Yes, and then you have in the chat the same link to the quiz Mentimeter. You have it also displayed on the screen. We wait for 15 seconds for you to connect.
There is no QR code on the screen now, Yanis.
There is no QR code on the screen?
No.
Okay. Control and...
Yeah, good now.
Now we see it. Thank you.
Super. Thank you.
Yanis, we are not hearing you, but okay, I will reread the 3 questions. So
Yes.
these are typical real life cases. So I immediately publish on everything. I call my TTO with my published manuscript, or I call my TTO with my unpublished manuscript. Well, they do better than average. So
Indeed.
no, I made the example of the bioarchive to raise awareness. Usually, when you contact your TTO with your manuscript not yet uploaded anywhere, they will ask you, they will analyze your technology, discuss with you the pros and cons of protecting, if it is the right moment, if you had other disclosure. So we assume that nothing that is contained in that manuscript was presented elsewhere. And then since on average, when you submit a paper, you have some time for the review period, you have some time in which you put together the patent, but you wait to file until the very day the patent is, I'm sorry, your paper is accepted. So in case it takes, I hope it will never happen to you, but in case it takes a year, you don't waste 1 year of the lifetime of your patent just because the publication was delayed. So you try to time these 2 things. Nowadays, beside bioarchive, where you actively put your manuscript, some journals directly publish your manuscript while still in peer review. So beware of the process and check it out when you submit your manuscript, if your TTO is waiting for the official publication online to file the patent. So that's one of the issue I wanted to raise, and now I will go back to the presentation. So while we wait, okay, so this is just to tell you, please talk with your TTO for assessment before any type of dissemination. Even if you want to go to a conference and you submit the abstract, talk with your TTO. They can help you write the abstract in such a way that it does not disclose too much. And in any case, if you need to disclose technical detail that would prevent subsequent patent, they will organize in order to file a patent before the publication also of the abstract. I say this because, of course, one of the technical requirements for an invention to be patentable is its novelty, besides inventive step and industrial applicability. Novelty means that nobody else could reason out that solution before that time. And if you talk about or wrote in an abstract something like that, even if it is yourself that wrote that abstract and published that article, it constitutes the so-called prior art. So when you submit your application for a patent, the examiner will say, okay, but somebody already told that, and it was you. So do not scoop yourself because of that. Your TTO will help you in assessing. And what happens when they help you assessing your technology? Let's take an example. You design a new genome editing strategy for a certain disease. So they will bombard you with questions, basically. So they want to know what is the technical problem. They want to understand your invention, how it is applicable, but also if you, of course, made disclosures, if you use the materials or technology from others in order to pursue your innovation in your technology. And the other things, and these are all the information that they need to understand if there is the feasibility, the technical feasibility to patent your innovation. But the other thing is to understand how to patent this innovation so that is useful to your project. So in the first technical assessment, they may ask you something, why you designed your innovation like that? What does it offer compared to the others? So basically, they will be your reviewer number 3 in making nasty questions, in understanding why your solution is better than others in order to make clear this competitive edge also in how they protect the technology. How they help you protecting the technology. They want to assess if you use the technology from others to understand if that technology is already patented and there is a space for your technology too to be patented. One example could be the use of Cas9 in your technology. Cas9 are patented. There is also a dispute on that. But the thing is that if you want to then commercialize your invention, you will need to ask a license to the owner of the patent of the specific Cas9 you need to exploit your technology. So these are things that you have to keep in mind, and your TTO will help you together with the IP firm that will write the patent if you don't have one in-house, in order to better frame your innovation and protect it so that it's usable in your project. And to be usable in your project, I will ask you to go around and make questions to your colleague, like why there is another approach for another disease or for the same disease in clinical trial. Why you would be better? Perhaps you will address patients that are not covered by the current therapeutic applications in development. And then they want to know which will be the next steps in your project in order to understand how you will use this in innovation and how to better frame the protection of this innovation so that it serves your project. In academia, rarely you protect just for the fun of it. You protect because the patent needs to serve your project, especially if you are developing therapeutics. So they will help you also gather some insights in which could be the development. And this information do not only shape the type of a framework around the construction of the patent around your results, but also how you want to exploit those patents later on. One of the questions that we often receive is that, oh, but actually, I use a piece of a construct, a piece of a plasmid, a material that a friend gave me, but I did all the work. Do I need to include them in the patent or only in the publication? And so what would you do?
And please connect again. The link is in the chat. And we are asking you a question about the plasmid and the friend here. 27. We have an average of 30 to 35 people who are active.
Yeah, don't be scared. The questions are
anonymous. The responses are anonymous.
The responses are anonymous, but I don't know how to say in English. You eat the leaves. I mean, you can figure out even if you didn't really listen to me, which is the answer.
So.
I think that is.
Okay. 1 sec. Going back and enter. So I used a piece of plasmid that a friend gave me, but I did all of the work. Do I need to include them in the patent? Absolutely not. Yes, they need to, or it depends on there is possible regulation using material transfer agreement. There is the possibility to have the contributor having an inventive contribution that is assigned to them, or collaboration agreement as well. And yeah, people are really intuitively.
Yeah, the fact is that doing the technical work, just the practice is not enough to say that you added an inventive contribution to the innovation, to the results. Because the inventorship, like we saw at the beginning, of a patent in a patent really relies on the inventive and the intellectual step that you put inside. So it may be that your collaborator give you the material and didn't had an inventive contribution. But at the same time, it may have give you the material under a material transfer agreement, which your institution signed, and among the clauses regarding the intellectual property management of the results that came out by the use of the material of your friend, you have to give them a little bit of, you have to evaluate the contribution based on the use of the material, not only on the inventive step that your collaborators put or did not put into the collaboration. And now back to the okay, so this is basically the summary of what I already said. So sometimes not only the inventive contribution, but also the materials, if you have agreement behind that, it could be a factor to involve your collaborators as inventor in the patent. So if the collaborator comes from another institution, the two institutions needs to sign an interinstitutional agreement and decide who takes the lead in marketing, that is making the world know that there is an asset that is very interesting, can solve a technical problem, can solve a medical need, and your TTO will help you in identifying potential industrial partners that would need that asset or that could be interested in co-developing with you that technology. And they can help you in solving, as we said, the conflict of interest that you may perceive in collaborating with the industry. But and they will help you talk with them, preparing materials and reason how to better approach industry, on how to respond when they approach you. So one of the questions we often receive from our scientists is that, okay, we filed the patent, so I know that my technology is protected. I also published the paper, and now a company wants to talk to me. What shall I do? And okay.
Sharing my screen.
Thank you, Yanis.
Okay, so participants are ready. So you filed the patent, you published the paper, and the company wants to talk to you. You will tell them every detail, or you don't tell anything until they sign a 6-figure check. Otherwise, you are the TTO's pet. So you have to prepare with them a non-confidential slide deck. Yes.
No, they already talked with their TTO. They didn't need this presentation. So,
No.
okay, so in the fortunate case, you just published the paper and filed the patent and you don't have any new data, it could also be that if you tell each and every detail, all the details you are going to tell them are already published in the public domain and you are not disclosing anything new or that can prospectively reveal what you are going to do next. Otherwise, it's always nice to decide on a set of non-confidential information, that is, the information that are in the paper, for example, that could attract the interest of a partner. So the medical need, if it's a therapeutic that you need to, that you are addressing, the population size that you are addressing, what the competitors cannot do that you can achieve. And in this way, you raise their interest enough to sign a confidential disclosure agreement that your institution will take care of. And in this way, reveal a bit more and understand better if they are interested in evaluating the asset, and then have establish the opportunity for a partnership. So
this leads us to the second question for you here. So question back. So yes, you have negotiated the collaboration agreement with the company, and what will you do next? You will work hand in hand with your TTO to get the best agreement for the development of your project, or you will do everything yourself. You sign whatever they send you, as long as they give you the money, you don't care, or you do absolutely nothing and wait.
There is a case in which you could do absolutely nothing, actually. That is if it is pure out licensing. Let's say that perhaps it applies more on the engineering side. Let's say that you develop a technology, or let's take the the Cas9 only as a type of invention. So it's something that is applicable in all possible that has so many applications. So probably you may keep some rights to develop it yourself, but you may also be interested in purely out licensing. So you give the license to a company, not in an exclusive manner, in a non-exclusive manner. So you will give the license to your asset to anybody who needs it without any exclusivity. And they will do all the work and you are not interested in co-developing or doing anything with them. But if you are developing a therapeutic, you are perhaps working closely with clinician, or you are a clinician yourself, you have access to patients, you really are into translating your research into a therapeutic, you probably want to be involved. And you can be involved in many ways, depending on the expertise you can bring to the collaboration and on the expertise of your institution or the other collaborators that are part of your project. And your TTOs and your institution can help you establish your contribution to the partnership so that what you get and what you give are in line with the needs of your project, including the turn back clause, of course. And so these are the two questions. And okay, so this is just what we just shared. And then, yes, we have another 5 minutes. So sometimes we get questions about how to deal with joint results within a project. So we get back to the to what we shared talking about IP rights under European Union grants. So if you give the heads up to your TTO, they can help you in understanding for that specific collaboration or grant agreement how to frame the usage of your background and the rights you have on the results you will generate in this collaboration according to the rules of the funding agency, or by establishing, for example, a proper collaboration agreement with other academic institutions to regulate a collaboration with them, even if you don't have a grant. And the questions that guides you and your TTO is that in understanding if you will be the sole owner of the results, or the collaboration will achieve something that is contributed by all parties. And so what you will do with these results, what you want to do, what your collaborators want to do, what you will do together, and if you can use freely those results as you are pleased. If it's using freely those results is useful for the project, because imagine that you have a patent on a genome editing approach for a specific disease. Especially in the rare disease field, it's very difficult that you can find two companies that will compete with each other to treat at the end a very few patients per year, because they will have no commercial profit from that. And as sad as it is, but it's something we have to keep in mind. So for example, if you develop a therapy jointly with somebody else, with some other institution, it's good to have some synergy and collaborate also in the exploitation activity. So to find a partner that will develop with both institutions or with the one that leads the development, but in a synergistic way and not in competition. And so these are all things that you can keep in mind to get the flavor of each and every collaboration. So to recall the example of the EU project, what your TTO will ask is, okay, so which is the background you need? Oh, it is something you already published, common knowledge, just research tools that you want to expand, so you don't have string attached. Maybe it's something you patented, and you also already out-licensed, so you cannot give free access to that background for exploitation purposes because you have a previous agreement with another industrial partner. So you will have to put a disclaimer with the collaborators. Then you have to understand if this background will be needed by others to implement the collaboration, or if you need the background of your partners to implement your activity in the collaboration, and understand that background, if it's free to use, if you do results, if you achieve results with that background, are you free to use to ask for access or to negotiate condition to access those background to then use it in your innovation? And so there are many, we try to make a specific case, I mean a mock case. So let's say that, for example, you are in a partnership with many partners, different expertises, and you develop an antisense nucleotide encapsulated in a nanoparticle to treat a certain disease. So we'll have partner one that has the disease knowledge, perhaps is also a clinician, knows perfectly the disease, the preclinical animal model, and everything. Then you have a partner number two, that as a background has a specific asset that allows them to design novel azo with increased property. And you have a partner that is able to design nanoparticle and has already found some interesting nanoparticle and is able to formulate drugs. So you win a grant and you achieve these potential therapeutics, but also other results. Like, for example, in addition to this potential drug X, one of the partner can improve their background and design something alone on its own background. Or, for example, the partner with the nanoparticle can understand, working with the partner that has the disease knowledge by testing the nanoparticle in the animal model, that it needs some amelioration, some better decoration for, I don't know, tissue tropism. And so they can also work on these on these different aspects, and you can have a plethora of results. So often then you go to your TTO and you want to understand who owns what. For example, oh, thank you, Yanis. So side by side, it's easier.
So we go to 30, and you have a row of 3 questions here.
Yeah.
So you got the collaborative grant, and together you will develop the drug X. The method was also developed. Who owns it? Who owns the method?
The method was what one of the partner designing the ASO achieved in, let's say, another software for designing an ASO, for example.
And yeah.
Yeah, in that case, it's pretty clear because they did everything on their own using only their background.
Then you go further and you will ask yourself, who owns the result, the lipid nanoparticle for disease D? Is it only the partner 1 and 3? Yes.
Yes, partner 1 and 3, 50-50. Only partner 3 because partner 1 just tested, or yeah, both the first and the last answer can be correct. The reason is okay. Then
you want to go to the explanation?
Well, we can comment it now. So the reasoning is that if you cannot separate the contribution, the EU says you do 50-50. If you can separate the contribution, it can be 60-40, 70-30, depends. The case in which is only of the partner that develops a nanoparticle, it would apply if you hire for service who test in an animal model. In this case, for how we wrote the description of the activity, partner one informs what you do. So it tells you, okay, no, in this region it cannot go, it affects toxicity in this way, so it informs how you develop better. So we see that there could be a contribution with them. Then it's assessed case by case, of course.
And then after the method and after the result, who owns X, who owns the drug in this case? So is it all the partners in equal share, or only the partner 2 and 3 because the partner 1 finally just tested it? Or is it the partner 1, 2, and 3, the 3, but the contribution is weighted? It's not 33% each, but it's depending on the efforts provided there.
Yeah.
So it's obvious. So
yeah,
the same explanation as the
it applies like before, let's say.
Yeah.
Then it's not always true, but sometimes it's not always true, because sometimes this type of research is initiated by those who owns the technology, like either the ASO or the nanoparticle, but it can also be that who has the medical need actually has the idea to develop an ASO and formulate with a nanoparticle. So the idea starts with who has the research need for a specific medical application and collect then. So the take-home message is then you have X that needs to be managed as an intellectual property, because probably there will be space, or at least there is a strong suggestion to assess if it is patentable, because then it becomes appealing to find a partner that helps you develop this asset. But you need to have your papers in order. So, and also between institutions to be ready for divorce. That is, sometimes academic institutions are really happy to patent, but patent expenses raises as the time passes. So not all academic institutions are allowed by their policy to sustain, I don't know, the entry in the national phases where there is a large expense in getting the protection in all different geography you need to ensure that the industrial partner has a good geographical protection of the asset. So you always hope to find an industrial partner before spending so much for a patent. But if it doesn't happen for many reasons and you still believe there is room for exploitation, you want to sustain those expenses. And it may be that one of the partners want to abandon the patent because it cannot sustain the expenses, and you have to regulate what to do in such cases. Then do we have a couple of minutes for the access right?
We can shorten this last one. Yes, this is important for access to background and results.
Yes.
Share in my screen.
Yeah, thank you. So since it's a European Union grant, there are access right to the background of the partners and to the results of the partners. So we are trying to make example on what could happen. But if you have questions that are not solved by this activity, please submit it to the mentee.
So here we are asking if the third party use access to the background, the lipid nanoparticle. Here.
So it's a bit small, but the first one is something like, of course, because partner, it's the background of partner 3. Okay, they were seeing better than me. Okay, yes, both the second and the fifth can be correct if the background was properly stated and the condition for access were clear.
Okay.
So you always have to be transparent about what access you can give on your background, but also, let's say, be smart and look at the background of the other partners that you need to complete your activity in the action and to potentially exploit your results. It requires some creativities in looking at the future and what you will need in the future, but try to do the exercise so you can negotiate appropriately with your partners.
Going further, there is another partner who is coming that wants to use the methods to design another class of therapy. So will the partner too give access to this new entering entity?
No, let's see it not as a new entity, but as a partner of the project that we didn't talk
yes.
about. Yeah.
Yes.
Yes, if it is an activity required by the project, they have to, they are entitled to the access because of the rules of participation, but is some kind of obvious, it should be obvious by the experimental plan in the proposal. If it was not obvious or it was not foreseen in the experimental plan, then I would say the access right helps you in getting access to the results of the other partners, certainly for research. It would be there is no access right granted in this case for exploitation because it was not foreseen, but it could be always negotiated.
And then I think it's the last one here. So let's think about the result methods that is only owned by the partner number 2. Can this partner grant an exclusive license on the results without informing the 2 other partners? All right.
Yes, if it is a result of the action, partner 2 is entitled to transfer, to even transfer, but also to exclusively license on one side only if the access rights are inherited in the contracts that they sign with the potential partner. But in any case, they are required to ask a waiver because it's an exclusive license to all the other partners that would need that access.
And we are at the end of
Yes.
our webinar. We are having only 2 slides.
We had one question on the first use case. I don't know if you want to answer it now.
Sure. In any case, we have the so I have to open the Mentimeter, right?
No, I will do it.
I can read it for you if you want.
Okay. So
how do I handle the plasmid friend problem if the plasmid was bought from a company? So it was from the first use case.
Yeah, you have to be aware. So many plasmid you buy, like Promega or even Agin, comes with string attached. But with Agin, you sign your institution signs an MTA to get the plasmid, and you can easily track back the conditions. So usually academic research is fine. Library screening, it depends how commercial if it fits into the definition of commercial use of that specific agreement that you sign with the provider. But most often than not, some plasmid that you buy on large providers comes with a so-called limited limited label license. That is, they attach a label on the box and you don't have a contract with that. Just because you open the box and you use the materials implicitly means that you accepted those conditions that you can find on the website, but usually you remember it when your TTO tells you, ask you, so did you use materials from commercial vendors? And then you check what you can do. So sometimes it happens that if you implement that piece of a backbone, etc., to then commercially develop your construct, you will need to ask a negotiate with them a commercial license. It has to be assessed case by case. One way that we try to, infuse in the mind of our researcher is that if you can, with to get away from the colleague or collaborators, if the plasmid is published, you can redo it yourself, so resynthesize it and use it. So you escape from the condition of signing an MTA that may require to give intellectual property to somebody that does not have an inventive contribution. But with the commercial plasmid, and even in that case, if there is a patent covering that material, even if you did the research all by yourself without the help of the material of your collaborators, if there is a patent, you will need on some part of that of your construct, you will need a license from the owner of that patent. So your patents to be commercially exploited depends on somebody else's technology or a piece of technology. Like the Cas9, you can patent, of course, a genome editing approach. The moment you need the Cas9 for development, you will need to negotiate sooner or later a Cas9. But beware of this limited use license, because they are the strings attached to your plasmid, and you will need to negotiate the license. Do we have other questions?
Nope.
Okay. Usually for this type of material, even for the commercial use of cell lines in like LTCC or other repository, there is a dedicated section on their site to understand how to ask for a commercial license for your applications. And so here we just have a summary of some of the tools that are available. As many of you know, both for the project developed within EJPRD and for the joint transnational calls project funded through EJPRD, an innovation management toolbox was created by EJP that is a collection of resources starting from intellectual property resources from the basics to more complex stuff, but also all the resources you may need to have a flavor of, to understand what are the next steps in the development of your assets. One, above all, is the Orphan Drug Development Guidebook that guides you to the process so that you have a flavor of what is ahead in the development of your asset. And for IP matter, especially related to European Union grant, the European Union funded a project that now is embedded in their activities, that is the European Union IP Help Desk, and where you can find a lot of materials, also some case studies, templates. Some templates are also available on the EJPRD website, and I think that's a lot to read, actually. So, and we are done, I would say.
And so, thank you very much. The last word is for you, Barbara and Stefano.
And I don't know if there are other questions also for Stefano, maybe.
Thanks for the audience for your 7 minutes patience as well. So we are 7 minutes past. And so for answering the first question that was submitted. Yes, the slides will be made available and the recording as well. The recording is automatically processed and shared with you, so you will receive an automatic email to get access to the recording. To watch it, you will not be able to download it, of course. We hope that we raised a little bit awareness on the IP or answered some of the questions that you have. We tried to have this webinar as something that will serve you now and in the future during the European Rare Disease Research Alliance and other projects as well. And we still have our help desk. Should you have any other questions, please do not hesitate to contact us as well. And we will be happy to answer. Thank you so much.